Welcome back to the Law and Crime Network. My name is Bob Bianchi. I'm going to be hosting for the next 3 hours, and it is my pleasure to bring back one of my old buds here on the show, Dan Schorr, who is the managing director at Kroll Investigations Firm. He's a former prosecutor, and Dan has just been a great guest for us, and he is now, and congratulations, a trial analyst for the Law and Crime Network. That's great, Dan.
Oh, thanks. It's great to be here. I love being a part of Law and Crime here.
Yeah, excellent. So listen, we got so much on the plate here today, Dan. The Bradshaw case, that amazing case with the wife swap DAs on trial, another DA testifying against him. He's representing himself. He actually rested after he said that he may actually testify. And not only did, there he is, a picture of him right now, not only did he not testify, he didn't even call a witness. So we're going to give the audience a recap of that as soon as anything develops inside that case. But we're also dealing with this Kentucky case, the Quincinio, Canada, and Dwayne Mulzam case. Now, that is where the victim is Jonathan Price. He is a 26-year-old Marine corporal who was actually shot and killed allegedly by these two individuals, Dan, and they are now facing capital murder charges, first-degree robbery, first-degree assault for an incident that occurred on June 21st, 2014. So far, I think this is another great case that the Law and Crime Network came up with. This is really, it's not going to be save his life, Dan. It looks like they're actually going for they didn't do it.
Absolutely. The defense is that they did not do it. And it's interesting because in a lot of these death penalty cases, there's just overwhelming evidence. The fact that the defendant or defendants committed the crime is not really in dispute. It's about the defense attorneys trying to save their lives. Here, the defense is that these guys are wrongly accused, that someone else did it. There's no self-defense claim here. This was clearly a murder. The question is who committed the murder.
Right, absolutely. And listen, the defense lawyers did a weird tactic in my mind. One chose not to give an opening statement. Never had a case where a defense didn't give an opening statement. The other defense lawyer did give an opening statement, and I got to tell you, I was listening to it before I got on the show, and Dan, I was like, I'm starting to think when she brought out all the different lack of evidence, and more importantly, and I think very compellingly, there was no DNA under the fingernails of the victim in the case. I think that's going to be pretty huge as far as putting some doubt, maybe somewhere.
The other big issue is the wife who survived. The husband was shot and killed. The wife was shot but not killed. Can she identify these defendants? There's questions the defense is raising about the identification, about a tattoo that one of them had that might have been taken off when there was a photo ID done. So that's going to be very interesting. Can they show that there was a proper ID done that establishes these defendants as the killers?
You know, Dan, what I love about the Law and Crime Network, it is the only show that's out there giving gavel to gavel coverage. I love that phraseology where people like you and me who have a lot of experience in trial work can work with our audience, the jury, if you will, in terms of looking at a case. So I ask all those people that are out there listening to this, I now have the Law and Crime app I just put on my phone, which is absolutely amazing. If you have any questions, go online, go to the Law and Crime Network. Feel free to ask them. You guys know I love answering those questions. Let's go to these defense opening statements. And remember, one defense attorney chose not to give an opening statement. This is the defense attorney who chose to give one, and talking about the lack of evidence and the things that the prosecution and the police did not do. And on the other end of that, we'll come back and discuss it with Dan. Welcome back to the Law and Crime Network. We know that there's activity in the court, but there's nothing happening now. And when it does, our producers will let us know. I'm here with Dan Schorr, and we're breaking down, he's trial analyst for Law and Crime Network, and we're breaking down the opening statement that was of one of the defense lawyers. The other defense lawyer chose not, interestingly, and hopefully I'll get a chance to talk to Dan about this, to give an opening statement, whether that was tactically sound. But Dan, what we're hearing right now is, and I wrote down some quotes here, this is reference to the previous robbery, and it was from that robbery and the forensic evidence, the ballistic evidence, that they connected it to this robbery. And she's basically indicating there that the police just had, and this is one of her quotes, they had their suspect and they weren't revisiting. It's what we call in the business confirmation bias, Dan. I've seen it a million times. She's basically saying they didn't identify facial tattoos, gold teeth on the suspects. What do you think so far about what she's bringing out that the police and prosecutors didn't do?
Well, certainly that's a strong opening for that defendant. She really laid out the problems that she sees in the prosecution case and why an identification was tainted here, that they airbrushed allegedly the defendant's tattoo on his face when they showed the photo to the wife, who was one of the victims here, whose husband was tragically shot. Now, the question is everything she's saying accurate? What's the prosecution case going to be? How are they going to lay out the identification? Are they going to show that the identification, other evidence tying these defendants to this shooting is sound and that they are guilty beyond a reasonable doubt? But that's certainly a powerful opening by that defendant. We'll see if the evidence is consistent with what she's saying are the problems with the case.
Well, Dan, listen, we have a feed back into the courtroom, and it looks like they're about to resume testimony, and we'll get back to the audience on the other end. Welcome back to the Law and Crime Network. What you're listening to there is the prosecutor's opening statement. I have to laugh at Mark Eigler telling me I'm not going to be able to pronounce these names right because he's probably right. But Quincinio, Canada, and Mulazam, Dwan Mulazam. I have Dan Schorr with us, trial analyst for the Law and Crime Network. And we're just in the prosecutor's opening statement, Dan, and we talk about the importance, moreover than a defense lawyer, of the prosecutor being able to paint a picture because they're the ones that have the affirmative burden to prove beyond a reasonable doubt. We looked at the defense. We kind of did it backwards here, which I love. And she was very specific, very in your face, I think, with the evidence that would and would not be presented in the case. And the prosecutor's giving their opening statement. So far, what are your thoughts?
Well, the prosecution is showing some strong connections that show these defendants might be involved in this killing. They have to prove it beyond a reasonable doubt, and the defense has raised some obstacles to that. But just looking at this robbery they talked about a few days earlier, not only was a gun that was taken, possibly used and connected to the murder, but then you have this thing where the two men who committed the robbery, one of them referred to the other as nephew, and apparently these two defendants, one of them does call the other one nephew. Now, that is kind of unique. You don't have a lot of pairs of two people committing crimes with one person referring to the other as nephew with similar descriptions. Doesn't mean it has to be them, but that, plus if they can have a solid identification put into evidence, that is powerful evidence.
Yeah, listen, one of our people online that are in the chat room, BB314, asked a question I think is really a powerful one because it's confusing to people sometimes. Why two defendants are being tried at the same time? Normally, I think they're under the belief it does not happen, but normally it in fact does happen unless there's a reason not to split it up. Can you talk a little bit about that, Dan?
Right. Well, if there's two people committing a crime together, they're probably going to be tried together. There are exceptions for when that happens. For instance, if one person's defense implicates the other person, like if one defendant's defense was, no, it wasn't me, but it was the other defendant, he did it with somebody else, then they would probably have to have separate trials because you'd have the prosecution accusing one defendant and the other defendant accusing the other defendant. So if their defenses don't align, then they would have to have separate trials. However, if their defenses align, and in this case the defense is aligned saying, we are not guilty because we didn't do it, it was somebody else, then they can be tried together. Now, in a very rare situation, you have some evidence that only pertains to one defendant, and you'll actually have two separate juries, and one jury will hear all the evidence except for that limited piece of evidence, and the other jury will hear that other evidence for just one defendant. But that doesn't happen very often. Right,
and I have a case right now, in fact, where one of the more common ones is where a statement is being given where the defendant is implicating another defendant in what we call a Bruton issue, where they have to sever the case because the defendant that's being accused through the co-defendant, I know it's a little convoluted, has a right to cross-examination against any witness against them, so you can't admit that statement and then use it against the person who has no ability to cross-examine because they have a right to remain silent. Anyway, guys, you are at the Law and Crime Network, the gavel-to-gavel coverage. We are listening right now to Kentucky versus Quincinio, Canada, and Dwan Mulazam, and we are in the prosecution's opening statement. We'll listen to a little bit more, and then a trial analyst at the Law and Crime Network. We'll get back to you after that. Welcome back to the Law and Crime Network. We were listening to the prosecutor's opening statement in Quincinio, Canada, and Dwan Mulazam. I should ask Mark Eigler for him to say the names and see if he could have done it better than me. Anyway, guys, we had a great conversation with Mark, and we have with us Dan Schorr, who is a legal analyst for the Law and Crime Network. Always great to have you here, Dan. We're listening to the prosecutor's opening, and she's spelling out the connection between this robbery that occurred at a hotel earlier, and then the connection that the police made ultimately to the murder of this Marine who was shot in the back and killed after a struggle. So what are your thoughts right now about how her cadence is, her presentation, and how she's laying that factual evidence out?
She's doing a good job. She's very methodical. She's going through the evidence. She's showing how the gun taken from that robbery was used. The serial number is consistent, was later used in the killing. She talked before about one of them calling the other one nephew. These two defendants, one calls the other nephew. And before we saw the first witness testified about his identification. That didn't seem 100% solid, but it certainly helped confirm that one of the defendants was part of the tandem that committed the robbery. Now, the question is going to be, is this all beyond a reasonable doubt? And there are defense arguments that put holes in it, such as the DNA under the fingertips of the surviving wife who was one of the victims in the shooting. Whose DNA is that if not these defendants? And the ID, was it tainted? Did they airbrush the tattoo on one of the defendants when the ID was made with her? Why did they do that? So there's certainly enough evidence to connect them to the crime to make what might be a strong case, but the defense has some holes in it that they're poking, and it's going to be interesting to see how that shakes out.
Yes, well, listen, just as a little sidebar, because we are the Gavel to Gavel Network, so we can take sidebars, too, just like they do in court. Don47, one of the guys that's in the chat room on the lawandcrime.com network, you are prophetic, because we were about to tell you that in the Wallace-Bradshaw case, the closing statements are going to be occurring in about 10 to 15 minutes, and you can watch them on the lawandcrime.com network if you wish. But of course, we would love to see you stay with me and Dan as well. But that answers your question, and you should know about it because it was a fascinating case. Dan, listen, I think that right now the prosecution's laying out this case piece by piece, and I'm just interested to see from this point forward whether or not there's one issue that really concerns me, and here's what it is. You know, as a prosecutor, you can get whatever you want. It's amazing. I drop a subpoena, I make a phone call, I get data. But I thought it was interesting when the defense lawyer said, we can't even get the AT&T records. And to this day, they're a mystery because we know the prosecution could have gotten them. I think that things like that are nicking the prosecution's case, despite how good this prosecutor's doing in opening.
Well, yeah, right. According to the defense, AT&T, one of the phones, or at least one of the phones was with AT&T, and the cell towers connected the phone or two phones to that area. But how big an area are we talking about? Are we talking about a couple of blocks? The defense attorney said it could be up to tens of miles, and that would obviously not pinpoint these defendants at the scene. And she was saying that AT&T will not disclose that information. So the prosecution can't be seen hiding something, but if they, too, don't have that information, they need to explain why they can't get it. Okay, great. Great commentary, Dan. Really appreciate it. Listen, let's go back to the prosecution's opening statement, and we'll have more commentary from Dan on the other end. Thank you. Welcome back to the Law and Crime Network. We are on break in Kentucky versus Quincinio Canada and Dewan Mulazam. I have Dan Schorr with us, who is the managing director of the Kroll. It's an investigative firm. Not only that, he's a trial analyst, an attorney. He's a great resource to us here at the Law and Crime Network. I love having you on, Dan. Great to be on with you. Yeah, listen, I know you got to go, but now that we're in the middle of the prosecution's opening, I'd like to hear what Dan's closing statement is about what you've seen so far. Sure. Well, first of all, just to take it to the beginning, this is a story about a 26-year-old Marine who was murdered. There are two people out there who killed him. He was a newlywed. He was planning to start a family with his wife, and he was murdered in cold blood, and this family is suffering this unbearable tragedy. Now, the question is, who did it? Did these two defendants do it, or did somebody else? And there's certainly evidence connecting these defendants to the murder. There was a robbery earlier where a gun was taken that seems to have been used in this murder. They might have been involved in that robbery. They might have been at the scene of the murder. But there's also questions that haven't been answered yet, and the defense is raising those. What about the DNA under the surviving wife who was shot What about the DNA under her fingertips that doesn't belong to these defendants? What about the identification that may not have been 100% according to guidelines? There was a tattoo on one of the defendants' faces that was airbrushed out for an identification. So there are certainly questions. This is a real case of who did it. There's a horrible tragedy. 2 people out there murdered this young Marine, and the question is, did these defendants do it, or somebody else who's out there, are they responsible?
Dan Schorr, Managing Director at Kroll. Always a pleasure, sir. Thank you for being here. And we are going to go back and resume with a little bit more of the prosecutor's opening statement, and we'll be back on the other end to discuss this fascinating case.